You're driving home late at night. Nothing illegal in your car, no open containers, no weapons, nothing you're worried about. Then you see the lights in your mirror. Your stomach drops a little, even though you know you haven't done anything wrong. The officer walks up, leans toward your window, and pauses. And then he says the words that have confused millions of drivers for decades. "I smell marijuana. Step out of the vehicle." In that moment, most people believe they have no choice. They believe the smell alone gives police the automatic right to search every inch of their car. And for a long time, that belief was mostly true. But what almost nobody realizes is that the law around this exact situation has been quietly transformed over the last several years. And in a lot of states, that old assumption is now dead wrong. So the real question isn't just, can police search your car if they smell marijuana? The real question is, which state are you in, what year is it, and does the smell alone still count as enough? Because the answer today is far more complicated than it used to be. And by the end of this video, you're going to understand exactly where the line is drawn and why so many searches that happen every single day are built on legal reasoning that courts are starting to reject. Let's start with where this all comes from. The Fourth Amendment protects you from unreasonable searches and seizures. Normally, police need a warrant to search your property, but cars are different. Back in 1925, the Supreme Court decided a case called Carroll versus United States, and it created what's known as the automobile exception. The idea was simple. A car can drive away. Evidence can disappear before an officer has time to get a warrant from a judge. So the court said police can search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. Probable cause. That phrase is the entire key to this whole video, so hold on to it because we're going to come back to it again and again. For decades, courts across the country treated the odor of marijuana by itself as automatic probable cause. If an officer said, under oath, "I smelled marijuana coming from the vehicle," that was treated as enough justification to search the entire car, the trunk, the glove box, containers inside, almost anywhere evidence could reasonably be hidden. This wasn't some fringe legal theory. It was standard practice in traffic stops nationwide, and it survived challenge after challenge in court. But here's the twist almost nobody sees coming. The entire foundation of that rule was built on one assumption, that the mere presence of marijuana, in any amount, for any reason, was inherently suspicious of criminal activity. And that assumption completely falls apart the moment marijuana becomes legal. Think about that logic for a second. If probable cause means a reasonable belief that a crime is happening, how can the smell of a substance be automatic proof of a crime in a state where possessing that substance isn't a crime at all? This is exactly the argument that's been working its way through courts in states that have legalized recreational or medical marijuana, and it's changing everything. Let's take a real example. In Illinois, after the state legalized recreational marijuana, the Illinois Supreme Court directly confronted this issue in a case called People versus Redmond, decided in 2023. The court ruled that the smell of raw cannabis alone is no longer automatically sufficient to establish probable cause to search a vehicle, because possessing a legal amount of marijuana is no longer inherently criminal in Illinois. The smell alone doesn't tell an officer that a crime is occurring. It might just mean someone legally transported cannabis in their car, which is completely lawful under Illinois law, as long as it's sealed properly. Colorado courts have wrestled with similar reasoning. In a case called People versus Zuniga, decided in 2016, the Colorado Supreme Court held that the odor of marijuana alone does not establish probable cause for a search when personal possession and use are legal under state law. The smell might indicate something completely legal happened in that car hours earlier, or that a passenger has a state-issued license to possess it. Now, here's where it gets even more interesting, and this is the detail almost nobody explains correctly online. Even in states where marijuana is fully legal, officers can still develop probable cause. The smell isn't automatically meaningless, it just can't stand completely alone anymore in many of these states. If an officer smells marijuana and also sees signs of impairment, erratic driving, visible smoke inside the vehicle while it's being operated, an open container of marijuana in plain view, or statements from the driver admitting to using it right before driving, all of that can combine to create probable cause, because now there's an actual indication of a crime, like driving under the influence. This is the part where people get confused because they hear the smell alone isn't enough anymore and they think that means police can never search their car over marijuana. That's not true either. Context still matters enormously. Now, let's flip to the states where recreational marijuana is still illegal. In states like Idaho, Wyoming, or South Carolina, where cannabis possession remains a crime under state law, the old rule still generally applies. If an officer smells marijuana in a state where it's illegal, that smell can still be treated as strong evidence that a crime is occurring inside that vehicle, and courts in those states have continued to allow searches based on odor alone, following the traditional probable cause framework. So the answer to the question in the title genuinely depends on where you're standing when the officer walks up to your window. Same smell, same words coming out of the officer's mouth, completely different legal outcome depending on state law. There's another twist that trips people up constantly, and it involves the difference between raw marijuana and burnt marijuana. Several courts have started distinguishing between the smell of unburned cannabis, which might just indicate someone is transporting a legal product, versus the smell of burnt marijuana, which suggests it was being smoked recently, possibly inside the vehicle, possibly while driving. Courts in some jurisdictions have found that the smell of burnt marijuana carries more weight towards suggesting impairment or an open container violation, even in legal states, because smoking marijuana while operating a vehicle remains illegal almost everywhere, the same way drinking and driving is illegal, even though alcohol itself is legal. So picture this. You're driving through a legal state, you have a sealed, unopened package of marijuana in your trunk, exactly the way state law requires, and an officer smells something faint. Under current interpretations in states like Illinois and Colorado, that alone likely isn't enough to search your car. But if that officer smells fresh smoke, sees your eyes are bloodshot, notices you fumbling with your wallet, and hears you slur your words when you talk, now you've handed that officer articulable facts beyond just an odor, and probable cause starts to build. This is why so many arrests and search challenges end up in court, because the entire case can hinge on exactly what the officer claims they observed and whether a judge believes that those observations, combined together, rise to the level of probable cause. Now, here's a fact that surprises a lot of people. Even when police do have probable cause under the automobile exception, that doesn't mean they can search absolutely anywhere without limit. The scope of the search still has to be reasonable based on what they're looking for. If they say they smell marijuana and are searching for drugs, courts have generally allowed searches of any area of the car where drugs could plausibly be hidden: glove compartments, center consoles, under seats, even closed containers and bags inside the trunk. This came from the Supreme Court's decision in California versus Acevedo in 1991, which held that police can search containers within a vehicle if they have probable cause to believe contraband is inside, without needing a separate warrant for that specific container. So even the sealed backpack sitting in your back seat isn't automatically off limits once probable cause exists for the vehicle as a whole. Let's talk about something else that catches drivers off guard almost every time. You do not have to consent to a search of your vehicle, ever. Officers are allowed to ask for consent even without probable cause, and plenty of people say yes simply because they're nervous, or they think refusing will look suspicious, or they just don't know they're allowed to say no. You are allowed to calmly and respectfully decline. Something like, "I don't consent to a search," is a completely lawful thing to say, and it does not give the officer any additional legal reason to search you. But here's the critical distinction. If the officer already has probable cause, whether from the smell combined with other factors or from something in plain view, your refusal to consent does not stop the search. Probable cause under the automobile exception overrides the need for your permission. So declining consent protects your rights on the record, but it isn't a magic shield if the officer already has enough legal justification independent of your consent. This is exactly why staying calm and saying as little as possible matters so much. Anything you say can add to what an officer uses to build probable cause. Admitting you smoked earlier that day, even hours earlier, can become part of the evidence used against you, even if you weren't impaired at the moment you were pulled over. Now, here's where we get to something most people have never even considered. What happens after the stop if the search happens and nothing illegal is found? Can you get anything back? Can you file a complaint? Does the search get erased from a record somewhere? The truth is that even lawful searches based on later disproven suspicion generally don't create grounds for a lawsuit if the officer had a reasonable, good faith belief at the time. Courts evaluate probable cause based on what a reasonable officer would have believed in that moment, not on whether the belief later turns out to be correct, which means an officer can search your car, find absolutely nothing, and still have acted completely within the law, as long as their reasoning at the time met the legal standard. That's a hard pill for a lot of people to swallow, but it's the reality of how these cases are evaluated. So let's bring this all together, because there's one insight that ties the entire video into a single idea. The legalization of marijuana in more than 20 states hasn't eliminated vehicle searches related to marijuana. It's changed the legal question being asked. Courts used to ask, does this smell suggest a crime? Now, in legal states, courts are asking, does this smell, combined with everything else the officer observed, suggest impairment, an open container, or some other actual violation? The smell went from being the entire case to just being one piece of a larger puzzle. And that shift matters far beyond marijuana cases. It reflects something bigger about how the Fourth Amendment actually works. Probable cause was never supposed to be a fixed checklist. It was always meant to evolve alongside what conduct society actually criminalizes. As laws change, the legal meaning of physical evidence, smells, appearances, behaviors changes right along with it. What counted as automatic suspicion 20 years ago might mean almost nothing today, and what seems harmless today could become significant again if laws shift back. If you ever find yourself in this exact situation, the smartest thing you can do isn't to argue the law with the officer on the side of the road. It's to stay calm, be respectful, clearly and calmly state that you do not consent to a search, and let the legal process, not the traffic stop, sort out whether that search was actually justified. Fighting it in the moment rarely helps. Fighting it properly, afterward, with the right information, absolutely can. Because at the end of the day, knowing your rights isn't about winning an argument on the side of a highway at 11 at night. It's about knowing exactly what to say, what not to say, and what actually happens next long before you're ever standing there with headlights in your eyes and an officer waiting for your answer. If you want to understand exactly what to say and what never to say during a traffic stop, especially when officers start asking questions designed to get you talking, there's another video in this series that breaks that down piece by piece, and it might be the most important 4 minutes you spend all week.